Welcome back, everyone. This is Lesson 2.3, Consequences of Using Prohibited AI Systems, within Module 2, which focuses on prohibited AI practices under Article 5 of the European Union AI Act. In the previous lessons, we delved into the specifics of what constitutes a prohibited AI system. Now, we're going to explore the very real and very serious consequences of not adhering to these prohibitions. It's crucial to understand that the EU AI Act isn't just a set of guidelines. It's a regulation, meaning it has the force of law across all EU member states. And with that force of law comes significant penalties for non-compliance. This lesson will focus primarily on those penalties, but it's important to remember that the consequences extend beyond just monetary fines. There can be reputational damage, loss of market access, and even legal action from affected individuals.
Let's start by discussing the structure of the penalties. The AI Act takes a tiered approach, meaning the severity of the penalty is directly related to the severity of the infringement. The most severe penalties are, unsurprisingly, reserved for violations of Article 5, the prohibitions. Why are the penalties so steep for prohibited AI systems? Because these systems, by their very nature, pose unacceptable risks to fundamental rights, safety, and the very fabric of a democratic society. The EU is sending a clear message. These practices will not be tolerated. Think of it like this. Some traffic violations result in a small fine, while others, like reckless driving that endangers lives, can result in hefty fines, license suspension, or even jail time. The AI Act mirrors this logic. Using a high-risk system that doesn't meet transparency requirements is one thing. Deploying a system that manipulates individuals' behavior, scores citizens socially, or uses real-time remote biometric identification in public spaces for law enforcement without strict justification is something entirely different, and the penalties reflect that difference. Now let's get into the specifics. The Act outlines different levels of fines, and it's essential to understand the distinctions. The highest level of fines is reserved for violations of Article 5. These can reach up to 35 million euros, or if the offender is a company, up to 7% of its total worldwide annual turnover for the preceding financial year, whichever is higher. Let that sink in for a moment. For a large multinational corporation, 7% of global turnover could be billions of euros. This isn't a slap on the wrist, it's a potentially crippling financial blow. Let's break down an example. Imagine a company, Global Tech, develops and deploys an AI system that uses subliminal techniques to influence consumer purchasing decisions. This system, let's call it Persuade AI, is embedded in a popular social media platform. It analyzes users' data and subtly alters the content they see, pushing them towards specific products without their conscious awareness. This is a clear violation of Article 5, which prohibits AI systems that deploy subliminal techniques to materially distort behavior in a way that causes or is likely to cause significant harm.
Now, suppose Global Tech has a total worldwide annual turnover of 50 billion euros. If they are found to be in violation of Article 5 because of Persuade AI, they could face a fine of up to 7% of that turnover. 7% of 50 billion euros is 3.5 billion euros. That's a staggering amount, and it demonstrates the EU's commitment to enforcing these prohibitions. Even if Global Tech were a smaller company, with a turnover of, say, 100 million euros, the fine could still be up to 7 million euros or the 35 million euro cap, whichever is higher. It's important to note the wording here, up to. The actual fine imposed will depend on a number of factors. The authorities will consider the nature, gravity, and duration of the infringement. They'll look at the number of people affected and the level of damage they suffered. They'll also consider whether the company acted intentionally or negligently. Did Global Tech knowingly deploy a manipulative system, Or was it a case of reckless disregard for the potential consequences? The answer to that question will significantly impact the final penalty. Another factor is whether the company has a history of similar infringements. Repeat offenders are likely to face harsher penalties. And importantly, the authorities will also consider the size and market share of the company. This is to ensure that the fines are proportionate and have a deterrent effect, even for the largest corporations. A small fine for a multinational might be seen as simply a cost of doing business, but a fine that represents a significant percentage of their turnover is much more likely to force a change in behavior. Furthermore, the level of cooperation with the authorities is a key factor. Did Global Tech proactively report the issue and take steps to mitigate the harm? Or did they try to cover it up? Full cooperation and a demonstrable commitment to rectifying the situation can lead to a reduced penalty, although it won't eliminate it entirely.
Now let's move on to the next tier of penalties. These apply to non-compliance with other obligations under the Act, excluding the prohibitions in Article 5. This could include things like failing to meet the requirements for high-risk AI systems, such as data governance, transparency, or human oversight. It could also involve violations related to the obligations of providers, importers, distributors, or deployers. For these types of infringements, the fines can reach up to 15 million euros, or, for companies, up to 3% of their total worldwide annual turnover for the preceding financial year, whichever is higher. While these fines are lower than those for violating Article 5, they are still substantial. Let's consider an example. Imagine a hospital using a high-risk AI system for diagnosing a specific type of cancer. This system, let's call it Cancer Detect, is designed to analyze medical images and identify potential tumors. Suppose the hospital, as the deployer, fails to properly monitor the system's performance, as required by the AI Act. They don't keep adequate records, and they don't have trained personnel overseeing its operation. As a result, a significant number of false negatives occur. The system fails to detect tumors that are actually present. This leads to delayed diagnoses and potentially serious health consequences for patients. In this scenario, the hospital, as the deployer, could be found in violation of its obligations under the AI Act. They could face a fine of up to 15 million euros, or 3% of their turnover, whichever is higher. Again, the exact amount would depend on the specific circumstances, including the scale of the problem, the harm caused, and the hospital's response to the issue.
Finally, there's a third tier of penalties, specifically for supplying incorrect, incomplete, or misleading information to notified bodies or national competent authorities. This carries a fine of up to 7.5 million euros, or, for companies, up to 1% of their total worldwide annual turnover, whichever is higher. This might seem less severe than the other penalties, but it highlights the importance of honesty and transparency in dealings with regulatory bodies. Attempting to deceive or mislead the authorities is a serious offense in itself. For example, if a provider, during the conformity assessment process, knowingly submits falsified test results to a notified body to make their AI system appear more accurate than it is, they could face this type of penalty, in addition to any penalties related to the underlying non-compliance of the system itself. It's also crucial to understand that these administrative fines are not the only potential financial consequences. Affected individuals may also have the right to pursue legal action and claim compensation for damages. This could lead to significant additional costs for non-compliant operators. Let's talk about a hypothetical scenario. Imagine a company develops an AI-powered recruitment tool that is used by numerous businesses to screen job applicants. This tool, due to biased training data, systematically discriminates against certain demographic groups, leading to qualified candidates being unfairly rejected. This would be a violation of the requirements for high-risk AI systems, specifically those related to data governance and the prevention of bias.
Beyond the administrative fines, the company could face lawsuits from individuals who were discriminated against. These individuals could claim damages for lost job opportunities, emotional distress, and other harms. The cumulative cost of these lawsuits, combined with the administrative fines, could be devastating for the company. Moreover, there's the reputational damage to consider. News of non-compliance with the AI Act, especially involving prohibited practices or discriminatory outcomes, can severely damage a company's reputation and erode public trust. This can lead to loss of customers, investors, and business partners, with long-term financial consequences that may far exceed the direct penalties.
Another important point is that member states are responsible for laying down the rules on penalties and ensuring their effective implementation. This means there might be some variation in how penalties are applied across different EU countries. However, the AI Act sets the upper limits for fines, ensuring a degree of harmonization and preventing a race to the bottom, where companies might try to operate in member states with lax enforcement.
The AI Act also includes provisions for other enforcement measures besides fines. These can include warnings, non-monetary measures, and even the power to order the withdrawal or recall of an AI system from the market. In particularly serious cases, where an AI system presents an imminent risk to health, safety, or fundamental rights, authorities can take immediate action to prohibit or restrict its use, even before a full investigation is completed. Imagine a scenario where a smart toy, equipped with an AI system, is found to be collecting and sharing children's personal data without proper consent or security measures. This could be considered a serious risk, and authorities might order an immediate recall of the product to protect children's privacy.
The European Data Protection Supervisor, or EDPS, plays a specific role in enforcement, particularly concerning union institutions, bodies, offices, and agencies. The EDPS has the power to impose administrative fines on these entities for violations of the AI Act. It's also worth noting the role of whistleblowers. The AI Act incorporates protections for individuals who report infringements of the regulation. This is crucial for ensuring that violations are brought to light, even when they occur within organizations that might be trying to conceal them. Directive 2019-1937, often called the Whistleblower Directive, applies to the reporting of breaches of the AI Act, offering protection to those who come forward.
Let's now talk about some common misconceptions. One misconception is that the AI Act only applies to large tech companies. This is simply not true. The Act applies to all operators, regardless of size, if they are placing on the market, putting into service, or using AI systems that fall under the regulation's scope. While there are some provisions that take into account the specific needs of SMEs, including startups, such as simplified documentation requirements for microenterprises, the core obligations still apply. The penalties are structured in a way that considers the size of the undertaking, with fines being a percentage of turnover. But this doesn't exempt smaller companies from compliance. Another misconception is that the AI Act only applies to AI systems developed within the EU. This is also incorrect. The Act has extraterritorial reach, meaning it applies to providers and deployers even if they are located outside the EU, as long as the output of their AI system is used within the Union. This is a crucial point for companies operating globally. If your AI system's output affects individuals in the EU, you are subject to the AI Act, regardless of where your company is headquartered.
So, what are the key compliance considerations for organizations? First and foremost, a thorough understanding of the AI Act is essential. This includes identifying whether your AI systems fall under the prohibited, high-risk, or other categories. If you are dealing with high-risk AI systems, you need to implement a robust risk management system, ensure data quality and governance, maintain detailed technical documentation, establish human oversight mechanisms, and comply with transparency requirements. For prohibited AI systems, the message is clear. Don't develop, deploy, or use them. The risks are simply too high, and the penalties are too severe.
It's also vital to establish clear internal processes and responsibilities for AI governance. This might involve appointing a dedicated AI compliance officer or team, developing internal policies and procedures, and providing training to employees. Regular audits and assessments of AI systems are also crucial to ensure ongoing compliance. Transparency is another key consideration. Be prepared to provide clear and understandable information about your AI systems, their intended purpose, their limitations, and how they work. This is particularly important for high-risk systems, where deployers have specific obligations to inform affected individuals.
Finally, remember that the AI Act is a dynamic piece of legislation. It's likely to evolve over time, with delegated acts and implementing acts providing further clarification and detail. Staying informed about these developments is essential for maintaining compliance. The EU AI Act represents a landmark piece of legislation, setting a global standard for AI regulation. It's a complex and far-reaching regulation, but its core message is simple. AI should be developed and used in a way that respects fundamental rights, ensures safety, and promotes trust. The consequences of non-compliance are significant, not only in terms of financial penalties, but also in terms of reputational damage and potential legal action. By understanding and implementing the requirements of the AI Act, organizations can not only avoid these consequences, but also contribute to the development of ethical and trustworthy AI that benefits society as a whole.
In conclusion, the penalties for using prohibited AI systems under the EU AI Act are severe and far-reaching, reflecting the serious risks associated with these practices. Compliance is not optional. It's a legal imperative. By prioritizing ethical considerations, implementing robust risk management, and maintaining transparency, organizations can navigate the complexities of the AI Act and contribute to a future where AI is a force for good.